Hello, welcome everyone. Thank you for joining us. We're going to give it just 1 minute to allow people to join and then we'll get started. Welcome everyone. Thanks for joining. We'll get started in just a few moments. All right, well, I think we have a critical mass. So we'll go ahead and get started. Welcome everyone to today's webinar, Immigration Court Mega Masters, What You Need to Know. I want to introduce our speaker for today, and that is Sarah Mahoney, who's a senior staff attorney at the Massachusetts Immigrant and Refugee Advocacy Coalition in our Massachusetts Access to Counsel Initiative Program, or MACI, and she'll share more about that program during the course of the presentation. Today's presentation is in English only, but we have a Haitian Creole version tomorrow, a Spanish version on Thursday, and we are adding a Portuguese version for this coming Monday. So if you know others who might benefit from listening to this presentation in one of those languages, please share those opportunities with them, and I'll drop a link in the chat during the presentation as well. So with that, take it away, Sarah.
Thank you so much. Good afternoon, everyone. My name is Sarah Mahoney, and I'm a senior staff attorney for the MACI program here at MIRA. I will be presenting today on the Immigration Court Mega Masters and showing what you need to know before your next hearing in Immigration Court. This presentation today is in a webinar format, which means you will not be able to turn on your video or audio, but feel free to ask any questions you may have in the Q&A function on Zoom, and I'll refer to all those questions at the end of today's presentation. After today, we plan to email everyone who's registered for this presentation a copy of the slides, a recording of today's training, and any resources that we share during the Q&A. For today, we'll explain who we are, what MACI does, and what is happening in immigration court with the new Mega Master hearings. We'll cover what Mega Masters are, how to prepare for them, what to do at your hearing, and what to do if you cannot attend your hearing. We'll finish with important reminders and tips for finding trusted legal help, community resources, and avoiding scams. Before we begin, please remember that every immigration case is different, and this presentation offers general legal information, and it's not offering any legal advice. We are the Massachusetts Immigrant and Refugee Advocacy Coalition, or the MIRA Coalition. We are a nonprofit organization that supports all kinds of immigrant and refugee advocacy work in the state of Massachusetts. One program that MIRA Coalition supports is the Massachusetts Access to Counsel Initiative, or the MACI program. And MACI is a statewide program that provides free legal representation or immigration attorneys to people fighting against deportation in immigration court. If you have a general immigration question, call the MIRA Immigration Helpline at 508-293-1871. The helpline can answer general immigration questions and help connect you to other resources. Those that answer your call are not legal representation, and the number is also not an emergency number. With that said, for immigration assistance, if you're not sure where to start, the MIRA helpline can be a really good first step. So MACI stands for the Massachusetts Access to Counsel Initiative. It helps people in Massachusetts who have an immigration court case and may need a lawyer. If you qualify, MACI may be able to connect you with a free immigration attorney. Call the MACI intake line at 508-505-4588. 4588. If no one answers, please leave a message, leave your name and phone number. If you are detained, you may need to call more than once, and you may want to have a trusted family member call on your behalf. Interpreters are available for most languages, and calling the Macy line does not guarantee a lawyer because there's currently a long wait list, but it is a very important first step to see if you qualify for help. Okay, now let's take a quick look at how a case generally moves through the immigration court. First, you may receive what's called a notice to appear, or an NTA. This is a document that starts your case in immigration court. Check the information that is on the notice to appear, make sure that it's correct information about you, review the charges that are labeled against you, and look to see if a hearing date is listed on the NTA. Next, you will have master calendar hearings. This is where the mega masters and the hearings for those mega masters are happening. You may have more than one master calendar hearing. At the first hearing, the judge will explain your rights and may ask you if you need time to find an attorney. If you need more time, tell the judge. At later hearings, the judge may review the charges against you, ask you what type of relief you want to apply for, set deadlines, and decide the next steps in your case. If you submit your applications but do not immediately receive another hearing date, your case may be waiting for an individual hearing to be scheduled. So keep checking your case status. In individual hearing, this is also called a merits hearing. It's usually a longer trial-like hearing. This is where you can present evidence in your case, tell your story, and explain why you should be allowed to stay in the United States. The judge will then make a decision in your case, and you may receive the decision in court or later by mail. If the decision is not in your favor, you may then appeal your case to the Board of Immigration Appeals, or the BIA. In some cases, you also have the right to ask another higher court, the Federal Circuit Court of Appeals, to review the Board of Immigration Appeals decision. So this is them reviewing whether the immigration judge, erred in their decision to deny your case. The important thing to remember is that the immigration court is a long process. Today, we're focusing mostly on these master calendar hearings and how to prepare for them. At master hearings, the judge will explain your rights in court to you. First, you have a right to an interpreter in your best language. Next, you have a right to have a lawyer, but the government will not give you one for free. If you need more time to find an attorney, please let the judge know. If you cannot find an attorney, you still need to attend court and represent yourself. You also have the right to show evidence in your case and to see the evidence the government is using to prove their case. Additionally, the judge will review the charges on the NTA with you, and these charges are the reason the government says you may be deported. The charges may be explained to you as yes or no questions like, are you a citizen of the United States? And are you a national of your home country? And keep in mind that you have the right to respectfully answer these questions or decline to answer these questions. At the end of this questioning, the judge will make a decision as to whether or not you may be removed or deported from the United States. But a protection from this removal are applications like asylum. So the judge may ask you if you are afraid to return to your home country. And if you are, you should answer yes. The judge will also explain that you must go to every hearing, meet your deadlines, and keep your address up to date. Missing court or missing an important deadline can mean that the judge may decide to deport you from the United States. So please be sure to make every hearing and file everything on time. And finally, the judge will explain your right to appeal the judge's decision at the last hearing if you disagree with the outcome in your case. In addition to explaining your rights, the judge may also give you some important documents and deadlines. You may receive what's called a notice of hearing. This includes the date time, and type of your next hearing. Sometimes a notice of hearing is mailed after you've attended court, so make sure that the court always has your correct address. You may also receive a list of free or low-cost legal organizations called the pro bono list. You can call these numbers to try to find an attorney. Write down who you called, when you called, and what happened so you can show the judge that you're trying to find an attorney. The judge may also give you a blue sheet. It's called the EOIR or E33 change of address form. And this form must be filed with the court, with a copy also sent to the government to update your address in immigration court. And the judge may also give you deadlines for applications, documents, or evidence. You should write them down or make sure you don't forget them so you don't miss them. So what's happening in immigration court? Immigration court is now holding mega master hearings for people who do not have an attorney. A mega master hearing is a master calendar hearing in immigration court in person where many people are scheduled at the same time. There may be around 80 people in one courtroom for the same hearing. The court may move through these cases rather quickly, so it is important to show up early, in person, bring all your court documents, and listen carefully to the judge. It is also important to wait for your name and your A number to be called to speak with the judge, which may take time, so prepare to wait patiently. During the hearing, the judge will explain your rights, explain the charges against you, and may ask you to respond to those charges. The judge may also give you deadlines to file applications or documents and set the date for your next hearing. These hearings can move very quickly. Sometimes people are given short deadlines and final hearing dates for individual hearings with very little time to prepare. That is why it's very important to listen carefully, write down every deadline, keep all of your court documents, and try to get legal help as soon as possible. So please remember, hearing dates can change, and sometimes a hearing may be moved to an earlier date than expected. That means you should not assume the date you were first given is still your court date. You should check the status of your case regularly. Check your court date regularly, open any mail you receive from the immigration court, and make sure the court always has the correct address and contact information on file for you. This is extremely important because if you do not show up to your hearing, the judge may hold the hearing without you and may order you removed or deported while you are not there. Please do not rely only on an old hearing notice. Keep checking your case, keep your address up to date, and do not miss your hearings. The first thing you should do before a mega master hearing is check your court date and time often. Your hearing date or time may change, so do not rely only on the old court notice. You can check your case in 2 ways, by phone or online. We recommend checking both if you can, so you can stay the most up to date on your case. And the important thing to remember is to check this often, especially as your hearing date gets closer. One way to check your case is by calling the EOIR automatic hotline phone number. It's 1-800-898-7180. And this is a free automated phone line that is available 24 hours a day. You can use it to check things like your next hearing date, time, and location. You will need your A number, which is the number on your immigration paperwork that starts with the letter A and is 9 digits of numbers after that. When the system asks for it, just enter the 9 numbers only. And then you can also check your case online. Go to EOIR's case status website at acis.eoir.justice.gov. You'll need to accept the disclaimer terms provided by clicking I accept. And then you'll need your A number to look up your case as well as your nationality. Once you have filled this out, press submit. And your hearing information should populate, giving your name, A number, hearing date and time, court location, and the judge's name. We recommend checking the website and the EOIR phone hotline, especially as your hearing gets closer. And when the hearing information populates, another thing to check after seeing what date and time your hearing is and the location is to check whether your hearing says in person. If it says in person, you need to go to court in person on that day. Some people have seen their hearings change from internet-based to in-person, so it's really important to keep checking your case and do not assume your hearing will stay online just because it's marked internet-based before. So this is what I'm referencing, where it says in person. Sometimes it'll say internet-based, but this is subject to change as well as the date and time of your hearing. This case information on their website gives you the most important information about your immigration court case. It shows you your next hearing date and time, whether the hearing is in person or online, the type of hearing, which is listed right here. So right now we have master. It could be an individual hearing, which is your last hearing, and whether the hearing who is handling your case, which judge, as well as the court handling your case, and their information collected right here. So if your hearing is coming up soon and it's scheduled at court, you cannot easily attend, talk to a licensed immigration attorney as soon as possible. They can explain whether you should ask the court to change the hearing location and help you make the request correctly. And the main thing is to check this information often because the hearing date, time, and location may change. If you want to verify anything further, you can always call the number listed right here on the contact for the court location, right under the court's address. When you call that number, it's going to ask you to pick or prompt you to press the correct number for a language that you need. It offers Spanish and English. And then you can press 0 to speak to a court staff member. Okay. If your hearing says in person, you should go to the immigration court in person on the date and time listed. In some situations, you can ask the judge for permission to appear by video or WebEx instead. The judge decides whether to allow that. An immigration lawyer can help you understand how to make that request to the court. Do not assume that joining by WebEx is enough for your hearing that is scheduled in person. Unless the court has approved a different way for you to appear, you should plan to go to court in person that day. This is very important because if the judge decides that you are not appearing for your hearing and that you did not appear for your hearing, the hearing may continue without you and you could be ordered removed in your absence. So if your hearing information says in person, go in person unless the court tells you that you may appear a different way. Before your Mega Master hearing, make sure you know which immigration court you need to go to. In Massachusetts, your hearing may be in the Boston Immigration Court, the Chelmsford Immigration Court, or the Hartford Immigration Court. Check your hearing notice and your case information so you know the correct location. And also arrive early. Give yourself time to go through security, find the right courtroom, and check before your case is called. If other family members are part of your immigration court case, check whether they also need to attend in person. Each person has their own A number or immigration number, so check each family member's case to make sure the date, time, and in-person or internet-based status match. This is especially important for children. Unless the judge clearly says a child does not need to come, plan for them to attend. If the judge excuses someone from a hearing, listen carefully to whether this applies only to that hearing or all future hearings. Every case is different, so pay close attention to what the judge tells you about who needs to come and when. When you get to the immigration court, go to the front desk first. Tell the court staff your name and your A number, and they will tell you which courtroom you need to go to. That way you can also check in with the court so they know that you're here and they can go find you if you're not present in court. Court staff may ask you to wait so someone can take you to the courtroom, or they may tell you to walk down the hall and find the courtroom yourself. You may also see volunteers from LUCE or other community organizations who are there to accompany and support people at court. Let them know you want their help and they can accompany you. These volunteers cannot give you legal advice or speak for you during your hearing, but they may be able to help you with things like checking in, finding the right courtroom, and understanding where you need to go. Once you find your courtroom, go inside and sit down at the benches. Do not wait outside the courtroom just because it looks crowded. It's important that you are present in the courtroom so you can hear what the judges and their staff are asking you, and you can answer any questions that they may have for you specifically. When you get to the courtroom, the judge's clerk may check you in again. The clerk may ask you for your name and your A number, so they have that information ready. After you check in, you can sit on the benches in the courtroom and wait for your case to be called. There may be many people waiting, so listen carefully for your name and your A number. And when your case is called, go to the front of the courtroom and follow the judge's instructions, unless you're told differently. So when I refer to benches, this is what I'm referring to. It's right as you walk into the door of the courtroom. Then if you're asked to approach, you'll be going to the left table to speak to the judge. On the right side is where the government attorney will sit if he's in person or she's in person that day. Here may be a law clerk for the judge, as well as the judge's table. And where the interpreter would usually sit is on the left side of the judge. So once you're in the courtroom, stay seated and wait for your case to be called. The judge may call cases for people who have attorneys first, so don't worry if other people are called before you. Listen carefully for your name and the last 3 numbers of your A number. And when your case is still called, the judge may speak to you while you are still sitting on the benches, or the judge may ask you to come forward and sit at the table on the left side of this courtroom. Follow the judge's instructions and do not leave the courtroom until your case has been called and the judge says that you're free to leave. Make sure you bring a pen and paper with you to court. Listen carefully to what the judge says and write down any important information. Pay special attention to deadlines like dates when you need to be submitting an application, documents, or evidence, and also write down your next hearing date and time. It's important that you understand also what is happening during your hearing. If the judge, court staff, or anyone else is speaking in English and you don't understand, say something. You can ask the court for an interpreter in a language that you understand best when it's your turn to speak with the judge. Immigration court provides interpreters when needed so that people can understand and participate in their hearings. If the judge is speaking to you in English and you don't understand, please don't agree or say yes to their questions. Ask them politely for an interpreter in your best language. And if you cannot understand the interpreter, or the interpreter speaking the wrong language or dialect, also tell the judge right away. Do not be afraid to say, I don't understand, or ask for help. In these situations, the judge needs to know if you are having trouble following what's happening. Interpretation is very important. You need to understand what's happening during your hearing, and you have the right to an interpreter in your best language. When you speak, talk slowly and clearly and give the interpreter time to translate before you continue. And most importantly, do not say yes or agree to something that you do not understand. Say, I do not understand, and ask the judge to explain. Okay, make sure the immigration court always has your current address. If you move or your address changes, tell the court as soon as possible. This is important because the court may send you hearing notices, deadlines, or other important papers in the mail. If the court has the wrong address, you could miss some important information in your case or a hearing date. If your address changes, you need to tell the immigration court. One way to do this is using the blue sheet EOIR or E33 change of address form. And you can find this form online by searching EOIR 33 change of address. Then click the immigration court's website, where they provide a change of address form known as an EOIR 33 form. And then they've actually updated it online for you to fill it out online. So you just have to follow the instructions for the online form. Make sure you fill out carefully everything that it's asking for and send it to the immigration court handling your case. Updating your address is very important because the court may mail you hearing notices and other important information. In changing your address with another government agency like USCIS, or letting ICE know at a check-in that your address is changed, does not automatically update your address with the immigration court. So make sure the court itself has the correct address. If you miss a hearing, act quickly and try to get legal help. If you do not appear, the judge may order you removed while you're not there. So this is called an in absentia removal order. In some situations, you may be able to ask the judge to open your case again by filing something called a motion to reopen. You will need to explain why you missed court. For example, maybe you never received notice of the hearing, or there was a serious situation outside of your control. The rules and deadlines are different depending on why you missed your hearing. Save any proof that you can help explain what happened for your case. This could include court notices, screenshots showing what the online EOIR case status website showed you, medical records in certain circumstances, or your own written statements or other people's written statements about what happened. These motions can be complicated, so try to speak with a qualified immigration attorney as soon as possible. There may also be a filing fee depending on the reason for your motion. So the current fee right now for a motion to reopen before an immigration judge is $1,065, but there is fee exemptions and waivers in some cases that may be available. And we've linked the EOIR's payment portal for you to see where you need to pay that fee if it's applicable to you. This is one of the most important things to remember. Missing even one immigration court hearing can have very serious consequences. If you miss a hearing, the judge may order you removed while you are not there. Every time you move, you must also tell the immigration court your new address. Fill out a change of address form, the E33, so the court knows where to send important notices, and do this as soon as your address changes so you don't miss important notices. We recommend that you check your immigration court case status every week. Look for any changes to your hearing date, time, location, or whether it's in person. Do not assume your hearing information will stay the same. We also recommend you arrive to court early the days you have to be in person, so you have time to get through security and to check in. We also recommend that you take notes during your hearing, write down what the judge tells you to do, your important deadlines, and your next hearing date. And do not rely on memory. Write it down and check online to make sure that nothing's changed. So what can you do? Keep your address updated with the court, check your mail, and do not assume your hearing date is still the same. On the day of court, arrive about an hour early or so. You have time to go through security, check in, and find your courtroom. If you do not understand English well, ask for an interpreter in your best language, and do not answer questions you do not understand. Just simply say, I do not understand. I need an interpreter, and share your best language. If you miss a hearing or receive a removal order, contact a qualified immigration attorney or DOJ accredited representative right away, because deadlines to appeal or reopen your case can be very short. When you need immigration help, it's important to know who is allowed to give you legal advice. A licensed immigration attorney can give you legal advice and represent you in your case. A DOJ accredited representative who works for an approved nonprofit organization may also be able to help you. But be careful. Notarios, tax preparers, and interpreters are not lawyers. They cannot give you legal advice unless they are separately authorized to do so. Before you trust someone with your case, make sure they're qualified and authorized to help you. If you need immigration legal help, there are several places you can look. In Massachusetts, you can use the Massachusetts Legal Resource Finder and the Immigration Court's list of legal service providers, or the Massachusetts Legal Help Immigration Referral List to find free or low-cost help. If you live in Boston, the city of Boston also offers free immigration consultations. And if you live outside of the Massachusetts, you can use the Immigration Advocates Network Legal Directory to search for nonprofit immigration legal services near you. Remember, always make sure the person helping you is qualified to give you immigration legal advice. Using this QR code, you can access Macy's Court Immigration Support link tree, helping connect you with resources you may need for immigration court or other assistance. Additionally, another resource is the Boston Immigrant Justice Accompaniment Network, or BJON. They help assist people in the immigration system, from ICE check-ins to legal referrals. The hotline numbers are provided, and which one applies to you is based off the circumstances of your case. They also provide bond support, from helping pay bond hearing, bail, to support letters for bond hearings. Make sure to reach out to Bijan for assistance if you need help like this or in the future. Okay, and now I'd like to give an opportunity to address the Q&A questions people have shared in the question box. And please be sure to reach out and follow up with Mira if you have any questions, and follow us on social media platforms and reach out to us via email.
Sarah, I just wanted to call to your attention that somebody helpfully pointed out that in a particular courtroom yesterday, the person was actually seated at the table on the right instead of the table on the left inside the courtroom. So I guess this can change a little bit. It might be court dependent. There's also a lot of new immigration judges that might be doing things a little bit differently. So thanks for letting us know.
Yes, definitely. It's changing every day, right? But so I guess formally, if a judge tells you to sit at any one of the tables, please do so.
There are a few open questions in the Q&A and some which have been answered. I don't know if you want me to read them to you, Sarah, or if you want to review them.
Yeah, I see. Let's see. What if they don't provide an interpreter after requesting for one? I've seen this happen recently as well. Repetition is important, as well as making sure that you're on the record while you're asking for an interpreter, making sure it's clear that you're not understanding what's going on. I think escalating this further, if this is happening in bulk, might be another step, but it's important to note it on the record. That would be my important move, and to make sure for an individual hearing, because that's where you're provided for due process reasons, an interpreter in your best language. Making sure at individual hearings people are being set up with their best language is very important. So if they're not getting it that day, I would explain their best language on the record and repeat it multiple times, how they don't understand English and this is their best language.
I would also say, if I can add, that there are court watchers in observing many, but not all, master calendar hearings. And one of the things that they're looking for is due process violations. And there's nothing, more glaring than not providing someone with an interpreter when they're requesting one. So if there are court watchers, they should be noting that information, reporting that back to advocates. if you observe it, you can always report it back to us as well.
Okay. Can a friend advocate attend court with the person who has the case? So the answer is yes, but it depends. I've seen, for instance, issues with court security at the federal building, allowing people in if they don't have a court hearing. But I would remind them how immigration court is a public court. So anyone is supposed to be able to attend a hearing, especially those that want to observe as a friend or an advocate. But it's important that you let the person who has a case speak for themselves and do most of the heavy lifting while you guys are going through the court process. So that's my answer. Jess, has anything to add?
No, someone else helpfully added that they accompanied someone and they were not allowed to sit in the courtroom because there was no room in the courtroom, which when they're scheduling mega masters with 70 plus people to appear at the same time, that can happen. There was a new policy that was issued a few weeks ago that limited access for court observers in some circumstances, but in person, generally folks have been allowed to accompany someone. You might not be allowed to, sit at the front table with someone, but you should be allowed to be in the courtroom in most cases. And I see a question, anything one can do. I think if the question is anything one can do if they were turned away, there might not be anything that you can do in the moment, but you should certainly report that if there's court watchers present, or you can also let us know as well as advocates might not be able to intervene in a particular case, but are gathering information about kind of systemic access issues. And then I see that there's one more question, Sarah, that might be beyond the scope of what we want to cover today, but I'll leave that up to you.
Yeah, I don't mind approaching it a bit. So the question is, what happens if the asylum application fee was not paid when it was filed? Does the court still have a record of it being submitted? Can it be resubmitted with the fee? Now, this has been kind of an ambiguous thing throughout the changes that have happened with the fee payments at the immigration court. I think it's very case dependent. Did the person receive notice of the annual fee? Were they told verbally on the record to pay the annual fee? Let's see. And then does the court still have a record of it being submitted? My guess is yes. I'm not certain. I know that UIR has its own, the immigration court has its own system. So supposedly they would have access to that. But what we have been doing is making sure to always accompany the application with a receipt. So if you've already filed the application, filing the receipt of fee payment in immigration court is always a good idea. And if you're doing it on your own, I would print 3 copies of it, one that you can keep and get stamped by the judge, one you can hand to the judge, and one you can hand to the government.
And there's one more question that I think we should address. Can ICE detain people in the court building or outside the building?
Yes. So this is also a complicated question. Right now, there's current litigation that says that they aren't able to do it in the court building. But we all know that there's been instances of that. So I would always be mindful of the potential and have family planning prepared. But this should not deter you, because if you don't show up to your hearing, you will be removed in your absence. It's really important that you go to court for your own sake, to give yourself that chance at due process. But I know that this is a looming threat. It's just, I don't know if I can say any more broad stroke answers, but Jess, you might He might be able to address it for Boston.
Yeah, I mean, the additional thing that I would say is that we have not heard of any reports of ICE enforcement officers at or directly in front of immigration courts since June of 2025. So it's been over a year now since there have been reports of ICE enforcement officers at the immigration court. That, of course, is, subject to change at any moment. So we can't make any guarantees, but we can kind of share what we have seen. Virginia, I see you coming on if you wanted to add.
Yeah, I just wanted to add that it should not be a reason to not go to your court date, or just that it increases your chances of detention later if you decide not to go to your court date. So I wouldn't, if you're worried that you'll be detained if you go to court, your likelihood would increase that you'd get detained if you don't go to court. So we do encourage people to go to their hearings. And that's saying when you're thinking about who should accompany you to the hearing, you may want to think about who drives you there, how you get there, if you're worried about the possibility of detention. But we don't want people not to go to a hearing because they're fear of detention when you're actually increasing the probability of it if you don't go.
Thank you, Virginia. And there's a final question about the person who was turned away when they were accompanying someone that was at the Hartford Immigration Court. I will say I'm less familiar with what's happening at the Hartford court than I am with what's happening at the Boston and Chelmsford court. So you can certainly let us know and we can figure out who might be doing some court watch and court advocacy for Hartford and connect you. And that was the last question that we had in the chat. So we moved through this information rather quickly. Happy to stay on a couple moments if anyone is currently typing a question. But otherwise, thank you all for joining us. We will be sharing the slides in the recording. We want this information to be broadly available, and once again, we will be making the same information available in Haitian Creole, Spanish, and Portuguese over the coming days. So please feel free to share those opportunities. They're right on our website under the training, upcoming Know Your Rights training tabs. So thank you. I'm not seeing any other questions coming through, so I think we can close it off there. And thank you very much.